off with like maybe say introducing yourself, what you do, what your experience is?
Yeah, absolutely. So, as you said, my name is Megan Shapiro. I am a full-time practicing construction attorney up in Sacramento. I have been doing this for about 15 years now, a little bit less than that. Primarily representing subcontractors, although I do have some GCs and some owners as well, and have over the years. But again, mostly subs at this point. We are a full-service business law firm. I personally happen to cater mostly to construction businesses, but that means that we can do both litigation as well as the sort of what people think of as the transactional side of things. So we can help with corporate formation, strategic corporate formation strategies. In addition to, we do a lot of interfacing with insurance. So we can help on the legal side of the collaborative experience with insurance renewals, protecting loss runs when it comes to claims, things like that. So we like to be considered sort of a one-stop shop. We can handle employment issues that may arise for construction companies. So we kind of just offer a 360 support model for construction companies here in California.
Nice. All right, so we'll get it started, and I'm going to ask you a simple question. So, as a new contractor, you say someone's about to start building their business, what do you think is the number one thing they should start off with when it comes to contracts, or what advice would you give them?
So I don't think contracts is actually where I would suggest that they start, believe it or not.
Okay.
I think the number one thing, and I can't believe that this is a fight that I have to actually have with newer people who are entering into the industry, but you do need to take into consideration your corporate formation. It is never a good idea, and I'm sure you will agree with this from an insurance standpoint, Rocio. It is never a good idea to operate a construction company as a sole proprietorship.
Yes.
Yeah. So the number one thing that I would say if you're looking at starting a company or you're in the beginning stages of just starting your construction company is make sure that you are forming an entity so that you can allocate and isolate the risk and that you're not bearing it on an individual level. So that's the very first thing that I would suggest. The second thing is still not contracts. The second thing is actually insurance. And no, you didn't pay me to say that. That is genuinely my belief. I don't think you should be entering into projects, and you don't need a contract until you're entering into projects until you have your insurance nailed down, buttoned down, and actually like you are protected to the extent that you've decided based on your individual risk tolerance that you want to be protected. So once you have actually an entity, formed a corporation or an LLC or something like that, once you have formed your entity and you have dialed in your insurance, then we can start talking about contracts. So that's sort of my like top three in that order.
Yeah, you're right. And I think one common mistake that I have seen from my end is when contractors sign a contract without knowing what's being asked on the insurance requirement. You know, really, and it happens not just with, the early stages of construction, but also as well people who have been in the construction world for a couple of years, and they will sign a contract asking for a 5 million umbrella, and in reality, their project size is not that large, or they have something crazy such as a 4 million limit on their general liability, along with 30 million pollution and an added on professional liability. So I do think that you should read your contract, get your insurance in place before you sign anything.
Yeah, I couldn't agree more. In fact, I often advise subcontractors in particular to, while they're in the contract review and negotiation phase before they have signed it, not only should they be talking to me if they're my clients to make sure that we're on the same page with redlining and risk allocation and all of that stuff, but I specifically say to them, did you send this to your broker so that they can review the insurance requirements and make sure that you are actually able to satisfy these insurance requirements? So I always advise my subs to do that as one of the initial contract review steps along the way to actually loop the broker in immediately because they're going to have to issue the certificates of insurance anyway and the AI endorsements anyway. So why not get them involved early on in the process as well?
Yeah. And then I'm going to read something off the chat right here from Oteka. It says, lack of communication from the estimating team And then I have a contract with crazy insurance requirements. Super important.
Yeah, and actually, to sort of follow up on that comment, I agree with you completely, Otika. It definitely comes into play on the insurance side when it comes to the difference between the estimators and the project managers, for example, or whoever it is that ultimately is going to be responsible for owning the contract for the project. But it can go beyond that as well. I have actually had to litigate issues that all sort of arose out of scope miscommunications or misunderstandings because the estimators maybe didn't quite understand the actual scope that they were bidding. And it resulted in huge financial losses to my clients because they couldn't really recoup those losses via change orders because it sort of was in the scope that was bid. And so I could not agree more that having a clear line of communication between the estimators and the project managers is vitally important in the initial early phases of the bid process. And then, of course, when it comes down to finalizing it into the signed contract, particularly if your subcontract is, if it does if it incorporates the scope from the bid. So sometimes subcontracts will, instead of re-articulating what the scope is within the contract itself, it'll simply attach the bid as an attachment or an addendum to the contract, and they will say this is the scope. And so if the bid becomes the scope, then it's even more important that the project manager, or again whoever is reviewing and signing the contract, make sure that they're doing sort of a line by line comparison to make sure that what was bid is actually the work that's going to be performed and that the prices line up the right way, so that way we're not in a change order situation and a dispute down the line.
Well, you touch on a very touchy topic, change orders. Change orders is the battle that everyone fights, especially when it comes to, there's some type of design mistake and the general contractor expects, wants the subcontractor to change it or, to act on the work. And so let's talk about change orders because that's a huge thing and that's definitely an uphill battle that all my commercial contractors face.
Yeah,
What
absolutely.
documentation, what is the proper way to document a change order?
So I think that when it comes to change orders, it actually, the conversation and the risk management approach starts before we even get to documentation, because every single subcontract is different in terms of how it approaches change orders and the requirements in the contract for the proper submission of a change order, whether substantiation documentation is required at the time you initially submit the change order, or whether you can just do the change order and then the GC has to request substantiation documentation. The timelines around change orders can change based on the language in the contract, whether you as the subcontractor are actually required to perform even without a signed contract, as long as the GC has given you either a written or an oral directive to perform. So it's really nuanced around how change orders are, how they are dealt with and approached in the individual subcontract. So from my position, the best practice is change order management starts with the contract and really does start at the contract review and redlining phase before you've ever entered into the contract. So you can clarify some of those issues. I see a lot of ambiguities around the change order requirements and contracts that are ripe for the opportunity to clarify through redlines and negotiations on the front end. So that way everybody's on the same page. Everybody knows exactly what is expected of them and what they need to do when they get to that point in the project. Having said that, once you are in the project and now you've got this issue where there is a change in either a change in scope or something like that that's necessitating a change order, from a documentation standpoint, I am a huge fan of, and I recognize, my disclaimer here is this: I recognize that it is oftentimes impractical from either a relationship management standpoint or from a pure practicality standpoint, because a lot of these conversations are happening in the field. So I do
Mhm.
recognize that. But in an ideal world, I would love to have written documentation of all of those sort of in the field conversations that oftentimes happen between foremen, or even the phone calls that happen between project managers. It's fine to just do a follow-up email or even text messages. I will even take text messages as long as you, as a company, you have a specific procedure in place that all of your relevant key player team members know about, to get those text messages off of the phone and into the job file. We all know that unfortunately high turnover is just a part of our industry. And so, what I don't want to have happen is a dispute doesn't actually become an issue until 3 or 4 years later. And now there's been turnover. And so, either the foreman who had the conversation in real time in the field has left, or the project manager has left. And if you didn't have a system in place to get those text messages off of their phone and into the job file, they're gone forever. So, all of that work that you put into making sure that you documented those conversations with the follow up text message, hey, just confirming, you told me to go ahead and proceed with this work and we'll figure out the paperwork on the back end, or whatever those sort of informal conversations are, those are now lost. And now we're in a situation where oftentimes we've got the turnover on both sides. So now you have upper management at both the GC and the subcontractor in depositions testifying to their recollection of understandings of conversations that happen between people who aren't even at the company anymore. And so I would much rather always have, to the extent possible, as much documentation in the file, particularly around those conversations and communications. Equally with RFIs, I always want those to be attached to the job file. Those should be a part of it so that they're there if we need them down the line, because of course, RFIs can oftentimes form the basis of change orders. And so to the extent possible, I'm always a fan of as much documentation as you can reasonably get away with in light of managing the relationship with your GC that you have to continue to work for.
Okay, and then I'm going to ask you a second question on regards to change orders.
Yeah.
So let's say a change order is denied. They're not going to pay it
Mm-hmm.
because it wasn't approved. Typically that's how the uphill battle starts.
Yeah.
And let's say it's over 200K in change orders.
Mm-hmm.
When is a good time? When is a good time to fight it? Like when do you actually have a story, right? Because like you said, it all goes down to documentation at the end of
Yep.
the day.
Mm-hmm.
When is it a good time to fight it? And when do you say, you know what, the amount of legal costs it's going to take to fight this it's not worth it?
Yeah, so that is going to be a decision that is going to be individual to every company, because a $200,000 loss might be completely acceptable to a larger subcontracting company. They might be able to bear that loss and just sort of wash their hands and say, you know what, an expensive lesson learned. Whereas another subcontracting company may not be able to bear that kind of loss and still stay in business. And so that's the very first question, that if a potential new client comes to me, or even an existing client comes to me with this new issue, they always want the answer to that question too. They always want to know, is this worth fighting for? And that is always my question to them. I don't know. Can you bear this loss? If you can bear this loss, that's not necessarily the end of the inquiry. That doesn't mean you should always bear that loss. Then the next question is like, okay, well, you can bear the loss. So now we have flexibility to decide whether or not we want to pursue this claim. As contrasted with like the small guy who can't bear the loss, then we have no choice. We have to pursue it, right? It's like it's a do or die situation. We have to fight it or you're just going to go out of business. So we do. But if you've got the flexibility to make a choice, then the next question is, well, okay, do you have any ongoing projects with this GC currently? Do you plan to do future work with this GC? Is there a relationship consideration here that we need to be mindful of as we pursue this? Sometimes you can get creative with solutions that don't even necessarily involve me, and they sort of involve the kind of backdoor communications, especially if it's a long-standing relationship between a sub and a GC that have worked together for a while. Oftentimes those employees will have relationships, and there can be some sort of behind the scenes conversations to try to get something done informally. I have seen, although I don't necessarily endorse or love, but I have seen situations where a GC and a subcontractor have had a relationship like that, where it's spanned a decade. They've done numerous projects together. They've got numerous projects together in the pipeline. And there have been these sort of like hushed conversations of, nobody's willing to put this in writing, but if you take a loss on this one and walk away here, we'll make up for it on the next project with you. And it's this sort of like wink, nudge, handshake deal. And if you've got that relationship and you're okay taking that risk that they're going to follow through, then that's fine too. So ultimately, there's no bright line of like, oh, if it's $100,000 or more, we should always pursue it. There is no real bright line strategy, because it's going to depend on the financial situation of every single subcontractor and the relationship considerations. And so it is a conversation though. I mean, I think like it's worth digging into and figuring it out, whether it makes sense to pursue it or not.
Yeah. I'm going to ask, so I have a lot of followers on Instagram that are residential contractors. Now, let me
Mhm.
ask you this question, since I don't want to leave those guys out
Yeah.
from this information. So how do they protect themselves from a client that isn't paying an invoice? And second part too, how do you protect yourself from a situation like that when you're doing work for the insurance company? So insurance companies hire a lot of these subcontractors to do renovations,
Mm,
restoration, plumbing, roofing.
right.
So how would a residential contractor protect themselves? Oh, what's the best way a residential contractor could protect themselves and make sure that they get paid by their client?
Okay, so I just want to make sure that I understand when we're talking about residential contractors, the client is the actual homeowner. We're not talking
Yes,
about a subcontractor. We're talking about more like a
correct.
GC. Okay. Again, it's all going to come down to the contract. And of course, as I'm sure you know, Rocio, in California, the Contractor State Licensing Board has very, very specific and stringent requirements for residential construction contracts that absolutely must be complied with. I mean, the CSLB does not mess around, right? So number one is make sure that you are actively complying with all of the very detailed requirements for residential construction contracts in California. That's out of the gate, base level. Do not pass go if you cannot meet that base level requirement. Assuming that you have a CSLB compliant contract, the next step is making sure that the language in your contract has clear payment terms and clear remedies for if those payment terms are breached. So that includes things like interest accruing after a certain period of time of or a certain number of days late that the payment is, right? The other fortunate part about California is we have a robust mechanics lien statute, and that's the benefit for residential home builders, GCs. They always have lien rights that are available to them, assuming that they follow all of the pre-lien procedures again that are outlined in our state law that I'm not going to get into, but certainly speak to a knowledgeable construction attorney in your state to make sure that you're complying with your lien rights so that you're not waiving them. But we do have that option as well. So even if you end up in a situation where, let's say, the homeowner isn't paying because they've got like a financial crunch, that's what I see most often. Homeowners don't usually just breach contracts; they do it because they have to. Have to meaning they've like the cost unexpectedly was more than they thought it was going to be, or they ended up having another emergency that took those funds that they had set aside, and so they just don't have the money. They're not just willfully not paying. So in that case, the conversation is sort of like, okay, well, they would be paying you if they could, which means they don't necessarily have the money. So maybe pursuing a lawsuit for damages, monetary damages, isn't the best avenue. But you do have your lien rights, and that might be worth pursuing because, of course, that's the hammer of all hammers, and it is that you now have the ability to force the sale of the property to satisfy a judgment that is for the amount of money that you're owed. So you do have those types of situations. In some circumstances for residential construction companies, they may have an insurance claim against the homeowner's insurance, potentially. That's going to be a pretty nuanced analysis. Again, talk to your knowledgeable construction attorney and your insurance broker. They'll be able to guide you on that. But those are some avenues that they can protect themselves from owners who don't pay. As for how to protect themselves from insurance companies who might not make the payments for, I'm assuming what you're talking about is like there's been a homeowner claim, and so now the insurance company has hired the sub to do whatever repair on the claim. Is that what you mean by that?
Yes.
Yeah. Well, you know me, Rocio. This is going to come as no surprise to you and anybody that is that's here that has listened to me talk about insurance before. I love suing insurance carriers. So that's my answer to how you can best protect yourself against insurance carriers. That's a bit of a tongue-in-cheek answer, of course. Again, it's all going to come down to the contract that you have with the insurance company. For that type of relationship, there is no functional difference between the contract that you could be using with an owner directly and with the insurance carrier. It's just a different pot of money that's paying the bill. So the payment terms can be the same. And so everything that I said about making sure that your payment terms and the remedies for you in case there is a breach in the contract with the homeowner is equally applicable to the contract that you enter into with the insurance company. The twist on that is sometimes the insurance companies want to use their own contract. And so that's a little bit of a twist. Then it's going to be a matter of making sure that you are reviewing it and truly understanding what it says, doing red lines where appropriate, and using whatever negotiation strategies you have at your disposal to sort of push back on that. At the end of the day, though, when it comes to insurance, because I am so jaded with how poorly they have treated so many subcontractors that I've seen over the last 15 years, if you're getting, it's almost like a gut check or experience if you've dealt with them before. If they're pushing back on reasonable requests for red lines, like if they're pushing back on you want to shorten the payment terms or you want interest to attach if the payments are a certain number of days late, if they're pushing back on reasonable requests like that, to me, that's a red flag that might be worth walking away from it entirely. Again, I recognize that's a bit of a privileged position to take if you are just like project to project staying in business and you got it, like you got mouths to feed, right? You got employees to pay. You might not have the ability to just turn away work like that, but you can at least try your best to make the contract as fair as possible to you, to try to get as fair of payment terms as you possibly can out of the insurance companies.
Question for you. So what happens when the client gets an attorney to represent themselves and then asks the contractor to remove the lien from the property and they still refuse to pay?
Um, I'm painting this answer is admittedly my disclaimer is this is a broad brushstroke. There's always going to be exceptions. This is why people hate lawyers. We're always like, it depends. But so many times it does depend. So my disclaimer is that this may not always be the case. But having said my disclaimer, I'm hard pressed to think of a situation where I would be agreeable to removing a lien if I was still owed money. Because once you've removed it, you've lost your lien rights forever on that project. And if they haven't paid you, then now you have no leverage. You have no hammer, right? Like that's your biggest hammer. And if you haven't used it to extract payment and they haven't paid you with the lien already being there, if you just remove it for the sake of removing it without having gotten paid yet, they're not going to pay you. Yeah, you can still sue them for breach of contract, but if they didn't pay you with the lien on the property, they're definitely probably not, definitely probably. This is my lawyer, this is the lawyer part, right? They're probably not going to pay you in a lawsuit either. So I'm really, really hesitant and reluctant to ever agree to removing a lien if I am still owed money. I'm hard pressed to think of a time when I would ever agree to that.
Okay. Now I'm going to move on to a different topic, and the topic that a lot of people fear and they should fear when signing a contract: liquidated damages. Can you
Yes.
give us a broad definition of what liquidated damages means and why contractors should look into these terms when signing a contract?
Yes. I'm glad you talked about this because liquidated damages are a killer, right? Sometimes they are leading an entire dispute. So, definitionally speaking, liquidated damages are essentially a contractually agreed upon amount of damages that usually an owner is allowed to assess against a GC, and then sometimes a GC then assesses against subcontractors. That basically the idea behind them is it would be difficult to ascertain in the course of construction what the monetary damages are for delays. And so what we're going to do is we're all going to agree on a set amount per day, usually per day, that can be considered reasonable damages for a delay, a day for day delay. So how this normally actually happens is there is a delay for whatever reason, right? It doesn't matter the reason. There is a delay on the project that causes the owner to get upset. I almost cussed. Causes the owner to get upset and assess liquidated damages. They assess the liquidated damages against the GC. The GC then usually, depending on contract terms, will then pass down the liquidated damages assessment to one or more of the subcontractors who, in the GC's opinion, have contributed to the cause of the delay that necessitated or prompted the imposition of the liquidated damages in the first place. So that's the general lay of the land on liquidated damages. I forgot the rest of your question, but I have a soapbox that I want to go on for liquidated damages, but I want to answer your
Yes.
question first before I do. What was
Oh,
there another question there?
the second question is why contractors should look into this, should think about it twice before signing the contract.
Okay, yes. So good. That's a great dovetail into my rant. So, the biggest tip that I have here on liquidated damages in terms of looking into it in the contract review phase before you have signed the contract is do not simply rely on reviewing your subcontract that you are being asked to sign, because liquidated damages are usually actually established in the prime contract. So you want to make sure that you are very clear. There are a million reasons, by the way, to review and understand the prime contract, even though you can't redline that, of course. There are a million reasons to review it, and a whole list of key contractual provisions within the prime contract that you should be paying very, very close attention to. But for the purposes of this conversation, you want to look at the prime for the liquidated damages provision that is in the prime, because that's where all of the liquidated damages are going to originate. So it's important to pay attention to the liquidated damages provision in the prime, and then to see how the GC incorporates that provision into your subcontract. You're going to be looking for things. You're going to be looking for language around how the GC is contractually required to allocate those damages, whether the GC gets to unilaterally decide how to allocate those damages amongst the subs that may or may not have been involved in the delay, or if there is some evidentiary requirement that the GC must satisfy in terms of this justifying how they have allocated the liquidated damages. The big thing on liquidated damages that I wish I had not seen as much as I have, because it's super shady, is this. Too often I see situations where the owner and the GC have a good relationship, even though there's a delay on the project. They're still on good terms. And they will basically have an off the record handshake agreement where the owner will, quote unquote, assess liquidated damages against the GC so that the GC can pass those on to the subcontractor. But they will have the off the record understanding that if the subs don't pay it, then the GC doesn't owe it either. That is super shady, and in my opinion, I don't think there's a clear legal answer to this question, but in my opinion, that is not in compliance with the contracts that I usually see. So I mention it because if you are in a dispute where there are liquidated damages being assessed against you, the number one thing, if you take nothing else from this entire webinar today, the number one thing that you should do if you are in the situation where LDs are being assessed against you and you're now in a dispute about it, is find out from a documentation standpoint whether the owner has actually assessed those LDs against the GC and if the GC is required to pay them. The caveat is that maybe the GC hasn't paid them yet because maybe the GC actually is going to fight those, right? That's not what I'm talking about. That's not uncommon, right? The GC gets assessed it, but they haven't actually paid it because they're also disputing the assessment of the liquidated damages themselves. The difference in that equation is, like in what I'm talking about, the owner and the GC are holding hands against the subs. So it's owner GC versus subs. That's what I don't like. But when it's owner versus GC and subs, that's okay. That's not a problem. Then you're all holding hands fighting against the owner assessing those liquidated damages. I'm not talking about that. What I'm talking about is this sort of shady deal of like, hey, wink and nudge, GC, you won't have to pay this if the subs don't pay it directly. So what I want to know is I want proof that those liquidated damages assessments are real, and that regardless of whether the subs end up contributing to the payment of those LDs or not, the GC is still legally on the hook for them. Even if they argue about it, they're still legally on the hook for them. That's what I want to make sure. So that's my number one tip. Make sure that the GC and the owner are not in cahoots for the purposes of screwing you over for what I'm going to call fake or illusory or phantom liquidated damages allocations. And I will now get off my soapbox.
How does one get proof of that?
So, excuse me. Usually this is the downside. You can always ask, right? Like if you're at the point in the dispute where attorneys are not necessarily involved and it's still sort of like the project managers snipping at each other over email, you can always ask, right? Like you can always ask. But once you get to the point where there are attorneys involved in the dispute, then your attorney will be the one that is like pushing that issue hard.
Okay.
Yeah.
Yeah. I mean, I've had situations where they have been threatened, for liquidated damages. So tell me, I know there's two different types of delays. I think one's called like forgivable delay, or and then there's another one that's like or if it's something about it being, I have it here.
Excusable?
Yes, excusable.
So excusable delays tend to be delays to the project that will not result in an assessment of liquidated damages. You can think about things that sometimes will fall under the force majeure clause in a contract. Everybody is familiar with that term in a post-COVID world, right? Nobody used to know what force majeure was until COVID happened. And now everybody knows what force majeure is. So it could be, I know Otika's here and he's in Florida. They just had some extreme weather this last week. So let's say there's extreme weather, a hurricane or whatever, that stops construction for everybody just because like nobody can reasonably perform. That would be what I would argue is an excusable delay as an example, right? Like nobody can actually be safely out there. So yeah, of course it delayed the project for however long there was bad weather, but it's nobody's fault. And so nobody is going to have to bear the cost of that. That's an excusable delay.
Okay. And I'm assuming an unexcusable delay would be, let's say there was a change of scope, or there was a change order, and because the toilets weren't, now they're asking for different material, and the subcontractor now has to go back to their supply house, and there's a 2 week delay,
Yeah.
and that 2 week delay now caused this project to be delayed. That would be considered, that's a valid reason for liquidated damages.
So I'm going to parse that out a little bit. And
Okay.
this is going to be, there's going to be no clear answer to this. I'm going to give you my opinion because this would be exactly the type of thing that would be litigated because
Hmm.
everybody's going to disagree. So I would say that supply chain issues that are related to the original scope and no change are going to be considered inexcusable delay. The subcontractor is going to be responsible for that, and liquidated damages will be assessed. I don't agree with it, but even though the subcontractor has no ability to control their supplier, their material supplier, their vendor, has no control over supply chain issues. At
Hmm.
this point, post COVID, the GCs expect that the subs have a finger on the pulse of their material suppliers and have enough options for material suppliers that supply chain delays are no longer considered excusable. They were for a period of time during COVID. They aren't really anymore. If, however, the supply chain issue is in your example where you said it resulted from a change in work, they literally changed the type of material that they wanted or the component part or whatever it is, and then there was a supply chain, I would bet money the GC is going to try to argue that that's still part of what I said originally and is considered an inexcusable delay, and they'll try to assess LDs. But I would fight that tooth and nail. I believe, and I think you. I'm inferring what you think about this. So I was about to say I agree with you, but you didn't actually say what you think. Think I know. I don't think that that should be considered an excusable delay because it was the result of a change. And now you're asking us to, on shortened time, adjust to a different condition. And we now have no ability to control maybe this particular, to use your example, toilet is only produced by one material supplier. I'm stuck with whatever they can do for me. And so I would argue vehemently that that should be considered an excusable delay for which I cannot be assessed liquidated damages. But again, this is exactly the type of thing that I fight about all the time. That's like exactly the type of thing that always results in a lawsuit because everybody wants to dig their heels in, nobody wants to compromise, and it becomes a fight.
Okay. And then real quick, before I open it up to the audience, how is this different when you're dealing with an OSUP project?
How is which part? How is which part different?
So like liquidated damages. So you know how in OSA projects now, everybody kind of just splits. If one person has a claim, then it gets passed on to everybody else.
Yeah. So the big difference, I guess, and I'm gonna actually have to defer to you a little bit on this one, but
Okay.
I have never seen, I'll say it that way. I've never seen a GL carrier consider delayed damages to be a covered element of
No,
damages.
it's
Right.
not.
So and I'm just going to,
Not under general liability.
yeah, exactly. So if you're telling me that on an OSIP project that there is some equal allocation of delay damages, I haven't seen it because then it wouldn't have been a dispute that I would have been involved in. So that would be the biggest difference because if it's not an OSIP project and it's just everybody's got their own GL coverage, then that's going to be the lawsuit that we're going to fight about and there won't be insurance. If the lawsuit is purely about liquidated damages and there's no other workmanship claims, construction defect claims, or something that would trigger insurance coverage, then there won't be insurance. I'm just going to be hired as a private attorney and we're just going to fight about it and their insurance won't even be part of the conversation. So that would be the big difference.
Got it. All right. So now I'm gonna open it up. It's 11:38, and I'm gonna open it up to the people in the audience. So if you guys have any questions, feel free to chime in the chat, or you could unmute yourself and you could ask Megan for any questions that you may have. But But yeah, I think you touched a lot of good topics about liquidated damages. That was actually a lot of my comments on Instagram and LinkedIn. So it's definitely that. And I'm going to share your contact information with everybody, Megan. And you
Great.
guys can find Megan on LinkedIn. She's like very popular on there. And she also has a you have an upcoming event in Sacramento, don't you?
I do. So I'm doing a workshop at the Sacramento Region Builders Exchange Women in Construction Conference on September 19th. So I'll be doing a workshop there. I'm really excited about that. We're going to be talking about the powers of persuasion in the workplace. And if you don't mind, Rocio, can I talk about Savannah too?
Yes, yes,
Yay, because Rocio is going to be there. So
I am.
I'm also hosting my own conference in Savannah, Georgia, the last weekend of September, September 27th through the 29th. It is going to be for anybody in the construction space. Most people are from the LinkedIn community, and we are going to be getting together sort of informally on Friday night, Saturday night, and Sunday morning. But all day Saturday, we have a conference space reserved. So attendees will get breakfast, lunch, snacks, drinks all throughout the day. And we're going to be really focusing on taking our online connections and relationships and bringing them in person so that we can figure out ways we can collaborate and further support each other. So it's going to be a great time. Rocio is going to be there. We've got 3 sponsors so far: Jesse Hernandez, John Goose Dunham, and Lynn Randall. I'm in conversations with a 4th potential sponsor, but it's going to be a really great time. But tickets are selling fast. We have only a few left. So if anybody is interested in joining us in Savannah, it's going to be super fun, but don't wait to get your ticket.
Yeah, guys. So there you heard it, Megan Shapiro. You guys could catch her in Sacramento in September, and you guys could also catch us end of September in Georgia. So if you guys have any questions, feel free to email. I'm going to shoot a massive email to everybody that registered on here, and this link will be posted. A webinar will be posted around Friday.
Awesome.
So thank you so much, everybody, for joining, and I'll see you guys on the next one.
Thanks, everybody.
You did. Where are you?